They scoped out Logan Airport. They took whatever actions it took and for however long it took in order to then successfully hijack those two planes with 150 citizens on them. It was very clear to me that they spent a lot of time trying to determine what the line of least resistance is in their efforts to attack our country. And at the end of those two plane trips, unfortunately, there were thousands of others who perished as well. We have spent much of the last 8 years in trying to develop strategies in order to reduce opportunities for terrorists to exploit our vulnerabilities. Since 9/11, we have enacted legislation to secure the aviation, maritime, rail, mass transit, nuclear energy, and other sectors. But what we have yet to do is to act on comprehensive legislation to secure the facilities that make or store dangerous chemicals. Instead, we have relied on the incomplete and inadequate legislative language that was inserted into a 2007 appropriations bill excuse me, behind closed doors that amounted to little more than a long run-on sentence. The chemical sector represents the best of American technological might. Its products help to purify our water, make the microchips used in our computers, cell phones, and military technologies, refine our oil, and grow our food. But these same chemicals could also be turned into a weapon of mass destruction, something that we were reminded of last week when we learned of a disrupted terrorist plot to use hydrogen peroxide purchased in Colorado for use as a bomb in New York. Yet the incomplete 2007 legislation that gave the Department of Homeland Security interim authority to regulate chemical facilities included several glaring security loopholes. It exempted all drinking and wastewater facilities. It exempted all maritime facilities. It prevented the Department from requiring any specific security measure at any facility. So if there was a hole in a fence, DHS couldn't order it to be fixed. And if there was a cost-effective alternative to a particular chemical or process that greatly would reduce the risk the facility posed to the surrounding community, DHS couldn't order that either. And it prevented citizens living around these facilities from being able to ensure that regulations were being met or enforced. At the beginning of this Congress, Energy and Commerce Committee Chairman Henry Waxman and Homeland Security Committee Chairman Benny Thompson agreed on the need to quickly act to comprehensively and permanently ensure the security of all facilities containing dangerous chemicals. The chairman agreed to work together on two separate pieces of legislation. First, we would craft comprehensive chemical security legislation to require the Department of Homeland Security to build on the good work it has already begun, but do so in a manner that closed the loopholes included in the interim authority Congress provided several years ago. The Chemical Facility Anti-Terrorism Security Act of 2009 was introduced following 5 months of bipartisan Energy and Commerce Homeland Security staff negotiations and has the support of a wide range of labor and environmental organizations. Second, we would craft legislation to provide EPA with the enhanced authority to ensure the security of drinking water facilities in recognition of the unique public health role these facilities play in providing a safe supply of drinking water. The Drinking Water System Security Act of 2009, which is exclusively within the jurisdiction of the Energy and Commerce Committee, has the support of the environmental and labor communities and also the Association of Metropolitan Water Agencies, whose members utilities provide safe drinking water to more than 125 million Americans. Though the two pieces of legislation provide authority to two different agencies, their intent and purpose is very similar. The bills require EPA and DHS to coordinate efforts with one another to minimize duplication in order to ensure that we make an assignment to one of 4 risk-based tiers and implement the bill's requirements. We want to work together with all of the members of the committee as we move forward in this process so that we can act wisely, and we do so in a way that is consistent with the traditions of the committee. Let me now turn and recognize the ranking member of the committee, the gentleman from Michigan, Mr. Upton, for an opening statement.
Thank you, Mr. Chairman. Like every member on this committee and in the Congress, Homeland Security is a concern and certainly a priority. And today we are examining 2 bills that deal with the security implications of facilities that use various chemicals. I do have a number of concerns with the bills before us today. However, I will primarily focus my remarks on H.R. 2868, Chemical Facility Anti-Terrorism Security Act. There have been disagreements over how chemical facilities should be regulated to address security issues, but Congress was able to enact provisions to authorize the DHS to regulate security at designated chemical facilities. Rather than enact new legislation, we should give DHS the opportunity to fully enact the laws that we've already passed. I believe that it is too soon for Congress to start over with new regulations. I support a 3-year extension of the existing law to give DHS the time to finalize implementation of the security regs and allow Congress to determine what works and what doesn't. And I prefer that to what we're looking at perhaps today. We must legislate from a body of experience and accumulated evidence, not ideological notions of what sounds like a good idea, especially when it means stranding billions of dollars in investments at a time when we've frozen domestic financing market with a struggling economy. I've been made aware of a few real tangible examples on the impacts of this legislation, and I recommend to the members of this subcommittee that they talk to companies in their districts and states about how the legislation would impact them. This legislation is not just about chemical facilities, it also covers facilities with chemicals too. And it isn't something that's just going to hit the big guys. Small businesses will be swept into, then perhaps even swept overseas. A recent study looked at the impact of inherently safer technology, IST, mandate on oil refineries. IST may sound good, but it is in reality a government-mandated product substitution. Study found that in certain terrorist situations, sulfuric acid, the mandated IST, can be just as dangerous as hydrofluoric acid, which is commonly used today. But under the federally mandated IST, the refining process would require roughly 250 times more sulfuric acid than hydrofluoric. To put this into scale, we were talking about the difference between 1 and 2 truckloads per month versus 3 to 4 truckloads each day. The IST, which doesn't make us safer, costs between $45 to $150 million per refinery, and an increase in operating costs of between 200 to 400%. What do you think would happen to gas prices in refineries moving abroad? Between this and cap and trade, we'll be stuck importing virtually every single gallon of gasoline from overseas. The problems with this legislation extends beyond the economic realm. The citizen lawsuit provisions in the Chemical Plant Security Bill are completely inappropriate for national security legislation. Allowing these types of lawsuits could harm security at these facilities, not make it stronger. Citizen suit provisions in the bill are an over-the-top example of why we should not be rushing, especially considering that terrorists hire lawyers and could use them. Citizen suits are not used in a national defense context and shouldn't be used here. Folks should not be able to compel the release of roadmaps to destruction by simply using the legal discovery process. Additionally, the information protection language rolls back traditional protections of information that Congress has employed since 9/11. It eliminates penalties against those who recklessly disclose sensitive information to the public. Even though we've been blessed not to have been attacked since 9/11, we should not relax our resolve to sanction violators swiftly or aggressively. In closing, H.R. 2868 would increase costs and send jobs abroad without bolstering national security. In fact, an argument can actually be made that it weakens our security. Chemical manufacturers have already invested millions of dollars in chemical security upgrades to ensure that the communities where they operate are safe, secure, and efficient. The requirements in this bill will not improve that security. It will only shift the security risk to other sectors such as transportation or manufacturing, while hindering the economic profitability in the process. Hundreds of thousands of jobs have been lost over the past year, resulting in plant closures and other facilities operating on the margins. Michigan's unemployment is still about 15%. The chemical industry has been hit hard by the economic recession, and now is not the time to jeopardize those jobs while weakening our national security. This isn't the right prescription for making our country stronger. We need a bill that secures the economy, not just re-engineers and exports. I yield back my time.
Right, gentleman's time has expired. The chair recognizes the chairman of the full committee, the gentleman from California, Mr. Waxman.
Thank you very much, Mr. Chairman. Since 2001, federal officials, the Governmental Accountability Office, and outside experts have warned that the nation's drinking water utilities and chemical facilities remain vulnerable to terrorist attack. The risk that hazardous but useful chemicals can be wielded against us is not theoretical or abstract. Just last week, we read news accounts that the FBI arrested an individual suspected of plotting to blow up a federal building using common chemicals purchased at a beauty supply store. It doesn't take much imagination to be concerned about what a motivated terrorist group could do with access to a facility containing large quantities of lethal substances. The bills we will learn more about today are unfinished business from 9/11. They are critical not only to Homeland Security, but to the safety of workers at these facilities and overall public health. First, I'd like to note the process by which this legislation was developed. At the beginning of this Congress, I sat down with Homeland Security Committee Chair Benny Thompson. We agreed that our committees needed to work together to address the vulnerability of chemical facilities to terrorist attack and other intentional acts. The Chemical Facility Anti-Terrorism Act, H.R. 2868, is a product of these discussions. This legislation will establish a chemical security program to address the threat posed by the nation's vulnerable chemical facilities. Committee staffs on both sides of the aisle spent hundreds of hours methodically working through these issues. The second bill we are discussing today, H.R. 3258, the Drinking Water System Security Act, creates a security program for drinking water facilities similar to the Chemical Security Program. While this legislation is exclusively within the jurisdiction of our committee, it is also the product of dozens of discussions on both sides of the aisle at the staff level. I can't claim we've achieved consensus on these bills, but they are well considered and respond to each of the concerns raised. I'd like to highlight what each of these bills will do. The Chemical Facility Anti-Terrorism Act begins with the recognition that DHS has made tremendous progress in developing a strong chemical security program and gives DHS permanent authority to strengthen security at America's chemical facilities. It then fills in some important gaps in the existing program. The bill requires all covered chemical facilities to assess whether they can adopt safer chemicals, processes, or technologies to reduce the consequences of a terrorist attack. The bill gives the Secretary the authority under certain circumstances to mandate that the riskiest facilities adopt safer technology. This is a common sense policy that will help make facilities reduce the likelihood that they will become an attractive terrorist target. We've also added an important citizen enforcement tool to the Chemical Facility Security Program, where citizens can use the provisions to hold DHS accountable for failing to perform their duties. H.R. 3258, the Drinking Water System Security Act, authorizes EPA to create a security program for our drinking water facilities similar to the Chemical Security Program under DHS. There are a couple of important aspects in that bill that deserve to be highlighted. First, the bill makes permanent EPA's authority under the Drinking Water Act to regulate security at drinking water facilities. Second, just like the Chemical Facility Bill, this bill requires all covered water systems that use a certain amount of dangerous chemicals to assess whether they can switch to safer chemicals or processes. Since states play a unique role in implementing the Safe Drinking Water Act and are most familiar with local drinking water concerns, we give the states, not EPA, the authority under certain circumstances to require riskiest facilities to adopt safer technology. We work closely with the water sector to balance the needs of safe drinking water with Homeland Security concerns, and I'm pleased that the Association of Metropolitan Water Agencies has endorsed H.R. 3258. AMWA is an organization representing the largest publicly owned drinking water system in the U.S., and we'll hear from one of its members on the second panel. We still have some significant issues to work through on these bills, and I hope we can find common ground to close these security gaps once and for all to make our country safer. Thank you, Mr. Chairman.
Great. Gentleman's time has expired. The chair recognizes the gentleman from Florida, Mr. Stearns.
Thank you, Mr. Chairman. I would say to you, Mr. Chairman, and to Mr. Waxman, in 2002 we passed the Drinking Water Security Act, part of Title IV of the Bioterrorism Act. And then we also passed the Chemical Plant Security Act in 2006. So I really think we should just extend those bills and see if the industry can comply. I think the industry is having difficulty complying with what we've already passed. So I agree with the ranking member, Mr. Upton, when he said just have an extension for 3 years and not start all over. Let industry comply with what we've passed. And as Mr. Upton said, see what works and what doesn't work and just correct it. You know, frankly, we haven't had a terrorist attack. We've had attempts, but we've really not had enough to drive these two bills to ask urgent passage. You know, and this is particularly a concern of mine when millions of Americans have already lost their jobs due to economic slowdown. And so you put these two bills in place, I think they'll have a negative effect on raising prices for everyday products, including food, water, pharmaceutical drugs, fertilizers, energy at a time when people can least afford the price increase. The proposed legislation goes beyond increasing security protections by imposing mandates on American manufacturers as to which products and processes they will use without any regard for practicality and availability or cost. Absent federal preemption and a uniform national standard, this legislation would create overlapping and conflicting security requirements that would cause disruption of federal security standards, increase government red tape, and obviously create more economic instability. So I'm here at this hearing, Mr. Chairman, but based upon what we passed in 2002 and 2006, I think the simple thing to do is, as Mr. Upton pointed out, just extend the bill, see what works, what doesn't work, because these folks are having a hard time complying with what we already passed. Thank you, Mr. Chairman.
Great. Gentleman's time has expired. Chair recognizes the gentleman from Louisiana, Mr. Melanson.
Thank you, Mr. Chairman. I appreciate the opportunity to do an opening statement. I, too, would like to thank you, Mr. Markey, and Chairman Waxman for your efforts to bring attention to this very important issue. My state is particularly affected by the proposals in this legislation. Louisiana is home to 61 chemical manufacturing companies that have 96 sites and at least 10 refineries throughout the state. These sites employ thousands of hardworking men and women, oftentimes multiple generations in the same plant. These jobs are not minimum wage employment. These jobs pay good salaries and offer a strong set of benefits. People are paying attention to this bill in Louisiana not only because of its potential impact on job and employment, but plant workers and the communities surrounding the facilities are also concerned for their safety. My son, Seth, works within the confines of one of those chemical plants along the Mississippi River in my district as a safety supervisor. And what I've come to learn through the years, and especially since he's become active in the industry, is that the key to every one of these facilities is safety, safety, safety. That is number one priority to all of them, management and workers. Despite existing rigorous safety protocols in these plants, there are still national and community security considerations addressed in this bill. Some of the chemicals we use every day in this country, such as chlorine, are used to make drinking water safe, but can also represent a real security hazard in the wrong circumstances. As we continue to work toward a final bill, we must balance national security with the needs to ensure that we do not create mandates that will threaten the jobs of tens of thousands of workers who are on the backbone of this vital industry. We must make certain that our efforts do not shift rather than eliminate risk. We must examine existing models and learn from the success of state chemical security plans. Finally, we must guarantee that critical security information is not made available to those who might use it to harm us. The Chemical Facility Security Bill being considered today has considerable expansions on the original authorization passed in 2006, and the motivation for this broadened initiative is commendable. However, I encourage my colleagues on this committee to keep an open dialogue with all parties affected by this statute, and remember that while our responsibility to secure this nation from terrorist attacks is paramount, we must also have a duty to legislate responsibly and consider all sides of the matter. I'd like to take the opportunity to applaud the groups such as American Chemical Council and CropLife America for their contributions in recent months and constructive viewpoints from the industry perspective. And I'd also like to recognize the Blue-Green Alliance for their diligence in making sure that there are strong protections for both the facility employees and surrounding communities. Lastly, I'd like to thank the committee staff and the staff of Representative Marty for working so hard to try and accommodate the interests of this wide variety of affected parties. With that, I yield back my time.
Great. We appreciate that. The Chair recognizes the gentleman from Texas, Mr. Burgess.
Thank you, Mr. Chairman, and thank you for having a hearing on this important issue. Securing our nation's drinking water and chemical facilities should be a priority for every member of Congress, indeed every congressional district. There's little doubt that these are centers where great damage could be inflicted on the communities and the surrounding areas. It does seem that there is disagreement on how to most effectively go about ensuring the safety of these facilities while at the same time protecting their economic viability. Imposing regulations on facilities that are still in the process of implementing Congress's last round of regulations does appear to be ill-advised at this time. Congress last addressed this issue of chemical facility security in the Homeland Security for fiscal year 2007 in the Appropriations Bill. The regulations put in place following the enactment of this legislation are in the process of being implemented, and the Department of Homeland Security has yet to make any on-site assessments regarding the covered facilities' compliance with the regulations. It seems to me a prudent course of action, indeed if any further regulations are necessary, would be to wait until the Department of Homeland Security has had an opportunity to report back to Congress, study their recommendations, and look at the success or failure of the current regulations. Chemical manufacturing facilities are some of the most highly regulated entities in the country, and in many cases for good reason. Moving the ball every few years by piling on additional regulations without assessing how well existing rules and recently created regulations are working creates both confusion and uncertainty for these entities. Having to redo and rewrite the security plan every year or two because Congress keeps changing course means businesses cannot focus on their core mission and indeed on their bottom line, growing their operations and creating more jobs. Congress should tread carefully when we consider extending security regulations to drinking water facilities, including facilities that serve relatively small amounts of people. I think it's important that we have the dialogue that we will have today, but more investigation is needed as to how to properly craft any legislation that would impose new burdens on drinking water facilities, which are already struggling to meet the demands of growing population, specifically in rural areas, and specifically in rural areas that I represent back in Texas. My concerns on both pieces of legislation that we will be discussing today center around the mandate of using inherently safer technology, but it's not always necessarily a one-size-fits-all application for all facilities. Further, the provisions allowing citizens to bring suits against covered facilities pose the potential for placing an additional burden on our court system and tying up the facility's resources in court proceedings rather than simply making their plants safer. I hope the hearing today will be productive and we'll enter into a dialogue how we may best go about keeping the American people safe and keeping chemical plants secure and drinking water supplies safe. I look forward to listening to the testimony of the panels today and working with others on the dais on these matters. Thank you, Mr. Chairman. I'll yield back.
Great. The gentleman's time has expired. The gentleman from Texas, Mr. Green, is recognized.
Thank you, Mr. Chairman, for holding the hearings today on H.R. 2868 and H.R. 3258. Legislation to seek to protect chemical facilities and drinking water systems across the country. Chemical facility security is especially important to the protection of public health and safety, and particularly in our congressional district. The Houston Ship Channel area is the heart of the largest petrochemical complex in our country that stretches along the Texas Gulf Coast, producing many essential products for modern life. People who live near and work in these facilities deserve the best security possible to prevent the risk of death or injury. Our industry, federal and state and local law enforcement have been working together since 2011 to do this. chemical facilities have already invested nearly $8 billion in security improvements since 2001 and are fully complying with DHS's chemical facilities anti-terrorism standards, or CFATS, which is not yet fully implemented. Today, DHS continues to review thousands of security vulnerability assessments to determine the nation's highest risk facilities that require appropriate risk-based security measures. Our hearing should shed some light on the progress of existing regulations for chemical and drinking water facilities so we can learn what's working and what isn't from these programs. We need to understand the impact of these pieces of legislation on the various responsibilities of EPA, DHS, and the Coast Guard, which regulates many of the chemical facilities in our district under the Maritime Transportation Security Act, or MTSA. In 2006, the appropriations rider that authorized CFACS exempted MTSA facilities to avoid unnecessary duplication. We should continue to avoid overlap with existing security programs, including in regarding background checks for employees. We have the same agency, Homeland Security and Coast Guard, looking at one plant that's on the water side and a neighboring plant that may not have water side. Those security standards should be the same. The hearing is also a good opportunity to learn more about the risk management concept of inherently safer technology, or IST, which is already in use in various chemical facilities today. If available, IST can be the most efficient step to improve security. The difficulties with IST is whether or how to involve government agencies like DHS that have few, if any, process safety experts, chemical engineers, or other qualified staff. Hopefully, we can promote the adoption of inherently safer technology while avoiding unqualified judgments and unintended consequences. I also question whether broad private right to sue authority, similar to civil suit provisions found in environmental statutes, is appropriate for the security legislation. It should be at least limited to the affected party, including the neighbors and employees that live near a facility. Mr. Chairman, I look forward to the testimony of today's witnesses so we can learn how to protect our communities with feasible and effective standards. And I yield back my time.
Great. Gentleman's time has expired. The chair recognizes the gentleman from Illinois, Mr. Shimkus.
Thank you, Mr. Chairman. More regulation, more cost, more uncertainty, less jobs. It's curious that we would try to move more legislation when we haven't fully enacted the previous legislation, nor do we have a full handle, or facilities have been inspected. And that's the frustrating thing in this environment, that we would move to do so. We are talking about more than based upon language, we're talking more than just chemical plants. We're talking about farms, hospitals, universities, deep underground wells. Based upon this terminology of substance of concern, I call it terminology of concern because it's undefined. Chemical facility security efforts are not a branch of environmental law. The use of inherently safer technologies is not a protection panacea against terrorism. Citizen suits are not used in national defense context and should not be used here. The last thing is the preemption regime in these bills allows states and localities to enact more stringent laws. That's obviously problematic. And with that, Mr. Chairman, I think we have a long way to go. We shouldn't rush, since the budget has a year extension, and there are folks who are pushing for time to look and review the process that's going on. And I yield back my time.
Gentleman's time has expired. Chair recognizes the gentlelady from California, Ms.
Thank you, Mr. Chairman. Today we will hear about the threat posed by toxic chemicals and the need to assure the security of those chemicals. As has been stated, we'll have testimony on two bills that seek to provide essential protections to millions of workers and communities now living in the shadow of preventable chemical disasters. Since 2001, we've had to reorder our priorities as a number of issues have taken on new urgency. The security of toxic chemicals and our drinking water remains very, very high on this list. Security experts continue to list the nation's chemical and drinking water plants as vulnerable and a deadly part of our nation's infrastructure. The threat is very real, and it requires immediate action, and that's why Congress must act quickly to pass protective and comprehensive legislation. H.R. 3258, the Drinking Water System Security Act, is an excellent start. This legislation will help us protect and secure our nation from potential acts of terrorism against our nation's drinking water facilities. It advances the use of safer, more secure chemicals and technologies where feasible and, importantly, involves plant employees in developing security programs. I'm pleased this bill has the support of the nation's largest water utilities as well as environmental and labor groups. This broad coalition shows that this bill provides a common-sense approach to securing America's drinking water. Mr. Chairman, just let me say that I understand the value of chemicals in our society. We're not here to question whether or not we need chemicals, but as a public health nurse, I'm well aware of the fact that what we need to do is protect those chemicals, especially the most hazardous ones, and also protect the employees that handle them every day from terrorist threats. Action is long overdue to address these preventable chemical disasters. All of us have a responsibility to make sure we do all we can to keep this country safe. I hope we can enact this legislation as soon as possible to eliminate that threat, and I yield back.
Great. Gentlelady's time has expired. The chair recognizes the gentleman from Oklahoma, Mr. Sullivan.
I'd like to waive my opening statement, and I'll submit a statement for the record.
Gentleman's time will be preserved. The chair recognizes the gentleman from Pennsylvania, Mr. Pitts.
Thank you, Mr. Chairman. I'd like to thank you for convening this hearing today on H.R. 2868, the Chemical Facility Anti-Terrorism Act, and H.R. 3258, the Drinking Water System Security Act. I think we can all agree that there is a great need to protect our chemical facilities from terrorist attacks. To this end, 3 years ago, Congress enacted Section 550 of the Department of Homeland Security Appropriations Act for 07. This section authorizes DHS to regulate security at designated chemical facilities. Though the law sunsets in a few days, there has not been enough time to fully implement the program. Realizing this, the Obama administration's fiscal year 2010 budget recommended a straight one-year extension of Section 550, which was included in the FY 2010 Department of Homeland Security Appropriations Act. However, there are several new provisions in H.R. 2868 that are very concerning. First of all, the application of inherently safer technologies, IST, is not a protection panacea against terrorism. The National Petrochemical and Refiners Association says, quote, IST is not a technique or procedure. It is an engineering philosophy. There's no valid method for objectively characterizing whether a process is as inherently safe as it can be, end quote. I do not believe it is Congress's role to mandate engineering philosophies or chemical substitutions as a security cure-all. In addition, regarding the citizen suits provisions, there's a great concern that every person, including terrorists, could use these types of suits to threaten litigation. Citizen suits are not used in a national defense context and should not be used here. Finally, as I mentioned earlier, the existing program under Section 550 has not yet been fully implemented. We need a full record of what works, what doesn't, what lessons we've learned before we change the rules. Mr. Chairman, there's no need to race legislation through this committee. Let's allow the existing law to be fully implemented, then take a careful, reasoned assessment of it. I appreciate the witnesses coming today and look forward to hearing their testimony. Yield back.
Great. Gentleman's time has expired. Chair recognizes the gentleman from California, Mr. McNerney.
Thank you, Mr. Chairman. I believe I'll waive my opening statement.
Chair recognizes the gentleman from North Carolina, Mr. Butterfield.
Thank you very much, Mr. Chairman, for convening this important hearing. You told us at the beginning of the session that we would have these hearings and they would be forward-thinking, and today is certainly an example of that. Mr. Chairman, one of the outcomes of that fateful day in 2001 was our expanded awareness of potential threats and vulnerabilities. In the wake of that tragedy on September 11th, we found renewed responsibility to secure chemical facilities and water treatment plants from intentional harm. We are exercising that responsibility in the consideration of these two pieces of legislation. Though my support for securing these facilities is unequivocal, I would be remiss not to convey concerns that I have received from some of my constituents with regard to the proposed legislation. The authority grants the Secretary of Homeland Security the mandate to mandate inherently safer technologies troubles many of these constituents that I represent. I am appreciative of the language for highlighting the Secretary's need to factor economic and cost concerns into the final determination on the need for ISTs. I urge that the economic consideration provision be as strong as possible. given existing incentives and CFATs for covered facilities to improve their security. Fertilizer producers and retailers in particular have expressed concern that the IST provision could be detrimental to their businesses. The First District of North Carolina is in large part agrarian, with many people dependent upon the farm economy. Yes, it's farm country for their livelihood. Fertilizer is a major input for these farmers, and increasing the cost of fertilizer has enormous consequences for the bottom line of the family farm. This is just one example, Mr. Chairman, of economic concerns, and I do hope that we keep these concerns and other concerns in mind as we go forward. I thank you for convening the hearing. I yield back.
We thank the gentleman very much. All time for opening statements has been completed. We'll now turn to our panel, a very distinguished first panel. And we will hear first from Rand Beers, who serves as the Undersecretary for National Protection and Programs Directorate at the U.S. Department of Homeland Security. In this role, Mr. Beers oversees the coordinated operational and policy functions of the Directorate's subcomponents, which include infrastructure protection, risk management and analysis, cybersecurity, and communications. Mr. Beers previously served on the National Security Council staff under Presidents Reagan, Bush, Clinton, and George W. Bush. So we welcome you, sir. Whenever you are ready, please begin. If you could move the microphone in a little bit closer and turn it on, that would help us.
Is that better?
Is it turned on?
I think it is now. Yes. The light is green.
Okay, great.
Yes. Thank you, Chairman Markey and Ranking Member Upton.
Could you lower the microphone just a little bit, please? Just push it down, the head up. Okay, good. Thank you.
Thank you, Chairman Markey, Ranking Member Upton, and distinguished members of this committee. It's a pleasure to appear before you today as the committee considers H.R. 3258, the Drinking Water System Security Act of 2009. This act is intended to close the security gap at drinking water facilities that possess substances of concern. We've enjoyed a constructive dialogue with Congress, including the committee, as it works on new authorizing legislation. The Department recognizes the significant work of this committee and others, particularly the House Committee on Homeland Security, that you all have devoted to drafting this legislation to reauthorize the CFATS program and to address chemical security at the nation's water systems. We appreciate this effort and look forward to continuing the constructive engagement with Congress on these important matters. CFATS is enhancing security today by helping to ensure high-risk chemical facilities throughout the country have security postures commensurate with the levels of risk. We have made significant progress since the implementation of CFATS in 2007. CFATS currently covers approximately 6,200 high-risk facilities nationwide. The current state of coverage reflects changes related to chemicals of interest that facilities have made since receiving preliminary tiering notifications in June of 2008, including security measures implemented and the consolidation or closure of some facilities. The following core principles guided the development of the CFATS regulatory structure: securing high-risk chemical facilities in a comprehensive undertaking that involves a national effort including all levels of government and the private sector; risk-based tiering that ensures that resources are appropriately deployed; reasonable, clear, and equitable performance standards that will lead to enhanced security; and recognition of the progress many companies have already made in improving facility security that leverages these advantages. It is important to note that the administration has developed a set of guiding principles for this reauthorization of CFATS and for addressing the security of our nation's wastewater and drinking water treatment facilities. These principles are that the administration supports a permanent chemical facility security authority and a detailed and deliberate process in so doing. Hence our preference for a full-scale process that will be completed in fiscal year 2010. Nonetheless, CFAT's single-year reauthorization in this session presents an opportunity to promote the consideration and adoption of inherently safer technologies among high-risk chemical facilities. We look forward to working with this committee and others on this important matter. CFAT's reauthorization also presents an opportunity to close the existing security gap for wastewater and drinking water facilities by addressing the statutory exemption of these facilities from CFATs. The administration supports closing this gap. The administration believes that EPA should be the lead agency for chemical security for both drinking water and wastewater systems, with DHS supporting EPA's efforts with its security expertise and the leveraging of the CFATS process and structure to include the risk-based performance standards, tiering methodology, compliance tools, inspector training, and other support. This will ensure that the water facilities identified as high-risk chemical facilities are addressed consistently nationwide with modification, where necessary, to reflect the unique characteristics of such facilities. With regard to policies surrounding inherently safer technologies, the administration has established the following policy principles in regard to IST at high-risk chemical facilities. The administration supports consistency of IST approaches for facilities regardless of sector, and DHS will be responsible for ensuring such consistency. The administration believes that all high-risk chemical facilities, that is, tiers 1 through 4, should assess IST methods and report the assessment in the facility's site security plans. Furthermore, the appropriate regulatory entity should have the authority to require facilities posing the highest degrees of risk, that is, tiers 1 and 2, to implement IST methods if such methods enhance overall security, are feasible, and in the case of water sector facilities especially, though obviously not exclusively, that such methods consider public health and environmental requirements. With respect to tiers 3 and 4 facilities, the appropriate regulatory entity should review the IST assessment contained in the site security plan, and the entity should be authorized to provide recommendations on implementing ISTs, but that entity would not require those facilities to implement those IST methods. The administration believes that flexibility and staggered implementation would be required in implementing this new IST policy. Clearly, this process could not happen overnight, and care and the collection of good data will be necessary. DHS, in coordination with EPA, would develop an IST implementation plan for timing and phase-in at water facilities designated as high-risk chemical facilities. DHS would develop an IST implementation plan for other high-risk chemical facilities in all other applicable sectors. The administration recognizes that further technical work to clarify policy positions regarding IST and water treatment facility security is required. The policy positions discussed above represent starting points in renewed dialogue in these important areas. DHS and EPA staff are ready to engage in technical discussions with the committee staff, affected stakeholders, and others to work out remaining technical details. We must focus our efforts on implementing a risk and performance-based approach to regulation, and in parallel fashion continue to pursue the voluntary programs that have already resulted in considerable success. Again, I thank you for the opportunity to discuss these issues with the subcommittee and look forward to answering your questions on this important issue.
Thank you. Thank you, Mr. Beers, very much. Our next witness is Peter Silva. He serves as the Assistant Administrator for Water at the Environmental Protection Agency, where he supervises water office programs implementing laws that include the Safe Drinking Water Act and the Clean Water Act. Mr. Silva is a civil engineer with 32 years of experience in the field of water and wastewater management. We welcome you, sir. Whenever you're ready, please begin.
Thank you. Good morning, Mr. Chairman, Ranking Member Upton, and members of the subcommittee. I welcome this opportunity to discuss EPA's efforts to promote security and resiliency in the water sector, with an emphasis on our role in addressing chemical security at drinking water facilities. I will also reiterate with my colleague from DHS our shared conclusion that a critical gap exists with respect to the water sector and the framework for regulating the security of chemicals in the U.S. The subcommittee has demonstrated both leadership and thoughtfulness in drafting a bill, the Drinking Water System Security Act of 2009, with the intention of closing this gap for drinking water systems. In my remarks, I will offer some comments on this bill, as well as the importance of EPA coordinating with DHS in addressing chemical security at water and wastewater facilities. EPA has worked over the last several years to support the water sector in improving security and resiliency, and I am pleased to report this sector has taken its role very seriously. EPA has been entrusted with important responsibilities for coordinating the protection of the water sector through congressional authorization under the Anti-Terrorism Act of 2002 and through presidential mandates under Homeland Security Presidential Directives 7, 9, and 10. Promoting the security and preparedness of the nation's water infrastructure is a priority of this agency in a post-9/11 and post-Hurricane Katrina world. A loss of water service can seriously jeopardize the public health, economic vitality, and general viability of a community. In working with the water sector, we have emphasized a multi-layered approach to security, consisting of prevention, detection, response, and recovery. We support the Drinking Water System Security Act of 2009 because it will enable us to reduce the risks associated with chemical security in the water sector without compromising the public health and environmental protection standards. We also support the structure of the bill as a steering process, vulnerability assessments, site security plans, risk-based performance standards, and other provisions are consistent with the proposed CFATS reauthorization language of H.R. 2868. With respect to that inherently safer technology issue, EPA and DHS support the bill's requirement for covered systems that use substances of concern above threshold levels to conduct an assessment of methods to reduce consequences, or MRCs. This requirement should promote the sector's consideration and adoption of safer methods. Further, we concur with authorizing the regulatory agency to require the highest risk facilities to implement MRCs under certain conditions. Although we find much to support in the bill, EPA and DHS share a significant concern with the bifurcation of the water sector under two separate bills, with wastewater facilities covered under H.R. 2868 and drinking water facilities covered under H.R. 3258. We urge the committee to authorize EPA in coordination with DHS to regulate chemical security at both drinking water and wastewater facilities. The committee's bill correctly recognizes the importance of coordination between EPA and DHS in regulating chemical security in the water sector. EPA and DHS have each acquired valuable insight through their respective experience with both the water and wastewater sectors. We recommend that EPA utilize DHS's existing chemical security risk assessment tools and performance standards and modify as necessary for the water sector. In implementing H.R. 3258, we envision that DHS would conduct initial reviews of vulnerability assessments and recommend risk tier assignments for water and wastewater facilities to EPA. DHS also would support EPA's evaluation of site security plans and train inspectors to ensure consistency of inspections nationwide. EPA also supports authority for the states to implement certain provisions, including a prominent role in MRC determinations and in both auditing and inspections. In conclusion, we have made significant progress in enhancing the security of our nation's drinking water and wastewater systems. With respect to chemical security, we look forward to continuing with working members of the committee on legislation that ensures the security of substances of concern at water and wastewater facilities while supporting the critical mission of these facilities for public health protection. Thank you again for the opportunity to testify about our role in water security, and I look forward to answering your questions.
Thank you very much, Mr. Silva, and again, we thank the witnesses for all their hard work and their work with our staff in moving towards today. And for the purposes of the question and answer period, Mr. Beers will be joined by Sue Armstrong from the DHS, and Mr. Silva will be joined by Cynthia Doherty from the EPA staff, if they'd like to come up to the table. And we welcome you both. The chair will now recognize himself, and we'll begin with you, Mr. Beers. There's been, Mr. Beers, many inaccurate statements made about the language in the bill that requires facilities to assess whether there are safer practices or technologies that they could use, and for facilities in the two highest risk tiers, the language that provides DHS with the authority to require them to be used in some cases. Some have said that the provision might shift the security risk because a company could change the location of the dangerous chemical or store it outside the facility's fence. H.R. 2868 says that before DHS can require a facility to adopt a safer process or technology, that it needs to find that there wouldn't be this kind of risk shifting. Do you think it makes sense to ensure that risk is not shifted?
Mr. Chairman, we certainly are of the view at DHS that as we look at any issue with respect to security, be it under the mandate that this committee is seeking with respect to inherently safer technology, or the screening and assessment process that DHS already undertakes, that measures to reduce risk are not shifting of risk to other areas. That's a basic bedrock position that DHS has held up to this point and would like to see continued as we consider any kinds of security measures.
Okay,
it does not help us otherwise.
Thank you. In H.R. 2868 says that before DHS can require a facility to adopt a safer process or technology, that it needs to find that the facility would be able to stay in business at its current location. Do you think that it makes sense for the Department to consider the costs before requiring a facility to adopt a safer chemical or process?
Sir, as we look at any kind of legislative impact, be it the existing CFATS legislation or what this committee has under consideration, we believe quite strongly that we have to take into account a number of factors, including economic considerations, in any move to seek facilities to change their practices. So in moving forward in an area concerned with inherently safer technology, we would certainly want to be able to take that into account.
Okay, thank you. Now, there have been some proposals to exempt small businesses from some of the requirements to assess and implement safer chemicals or processes. Do you believe that the risk to the surrounding community is smaller just because the business is smaller if Al-Qaeda could launch a successful attack on a chemical facility that was unprotected?
Sir, the risk process that we undertake in reviewing facilities looks at the risk as the risk exists. It's not an issue of whether a business is large or small. It's not, and the risk to a community is not determined by the size of the business. It's determined by the size of the risk. So as we look at these issues, we would be looking at the size of the risk. As I said in answer to my previous question, we would also take into account economic considerations, but risk is risk, and that's no difference between the size of the business.
In your opinion, is it reasonable to assume that Mullah Omar and Osama bin Laden in Pakistan right now have plans, if they could implement them, to strike at the United States once again?
Sir, it's the view of our intelligence community that Al-Qaeda and its affiliate organizations still represent a risk to the homeland of the United States. We have not deviated from that view across a change of administration, and the recent events in New York clearly suggest that that risk is alive.
And could chemical facilities be a high priority target for al-Qaeda within the United States if security was inadequate?
We certainly believe that chemical facilities represent a potential target. That was the purpose behind the original CFAS legislation. We continue to believe that that's the case.
Okay. Thank you, Mr. Beers, very much. Let me turn and recognize the gentleman from Michigan for his question.
Thank you, Mr. Chairman. Mr. Beers, the Congress passed in '06 and funded the chemical facility anti-terrorism bill and the '07 appropriation bill. How many facilities are actually impacted by the legislation in the United States? About, I don't know if you know the exact number or not.
I'm going to turn to my colleague here, Sue Armstrong, to answer that detailed question.
Good morning, and I'll apologize in advance for my voice today.
Sounds fine to me.
If you could just lower that microphone a little bit. Thank you.
There are currently 6,156 covered facilities in the 4 CFATS tiers.
And of those 6,156 facilities, how many of them have been inspected since the bills passed?
Well, the first regulatory deadline under CFATS was January 22nd of 2008 to file top screen, which is the initial consequence screening that a facility possessing Appendix A chemicals of interest must file with the department. And at that point in time, we had 29,453 top screens in. In June of last year, June 23rd, 2008, we notified 7,010 facilities nationwide that they were preliminarily tiered under CFATS and needed to do a security vulnerability assessment, again, under the program. And
then you dropped it down to 6,156.
yes.
And of those 6,156, how many of them have you actually gone to visit?
We have, well, we have done a number of compliance assistance visits over the past year or so to, number one, make sure we understand what we are seeing in a security vulnerability assessment, or if a facility requests a visit, we will pay them one.
So has that happened? Have you actually visited in any of these sites?
Yes, sir. Compliance assistance visits have been occurring regularly. Facilities are also able to visit us in Washington for a technical consultation regarding their tiering if they want to. We have not begun inspections formally yet. We expect to do so in December. The first site security plans for a group of Tier 1 facilities that were notified of their final tiering status this May were due September 15th.
Okay. The reason I ask that is that I know that in the budget request, the President's budget request that was made, he sought for a 1-year extension of the bill, which, as I understand it, the Homeland Security appropriation bill is going to comply with that. I think there's a 1-year extension in both the House and the Senate bill. And as a former OMB official, I know that this is about the time of year that the agencies submit their requests for the next budget to be presented early next year. Can you tell us where the Department of Homeland Security is as they look at the 11 budget? Are they going to pursue a 1-year extension again?
No, that's not our intention. That was a good faith effort to indicate that it was our preference that we work with the houses of Congress on a permanent reauthorization during fiscal year 10.
Are you aware of, from receiving the information from these 6,000 some facilities, that there are any shortcomings in the legislation in their compliance?
We have not taken any enforcement actions under the program at this point in time. We did receive approximately 6,300 total security vulnerability assessments, and we have been in the process of reviewing those since they were due at the beginning of, or late last year and the beginning of this year. We have Tier 1, 2, and 3 reviewed pending new submissions of top screen, and we're reviewing the Tier 4 vulnerability assessments at this time, and continuing to make final tiering determination notifications.
Mr. Beers, you said in response to Mr. Markey's question, you wanted to take into account economic considerations of the changes that they're making. Do you have any estimate of what these facilities have done financially to comply with the regulations that are on the books now? Do you have any total costs?
While I don't have a total cost, I do know, and you can see from the numbers, 7,010 initial preliminary tiering notifications and a covered population of 6,156 at this point in time. To me, that says that facilities are taking a look at their chemical holdings. They're taking a look at their internal corporate supply chain and security posture and making changes. The rule specifically provides that when a facility makes a material modification, it needs to refile its top screen with us. So we've had thousands of top screen resubmissions. We've received 36,960 top screens as of this date. So facilities are looking at their holdings, looking at their practices, and
I know my time has expired, but do you have any idea what the cost has been on these facilities to comply?
I do not at this point.
Thank you.
Great. Gentleman's time has expired. The chair recognizes the gentleman from Louisiana, Mr. Melanson.
I'm going to waive questions for right now. Thank you.
The chair recognizes the gentleman from Texas, Mr. Green.
Thank you, Mr. Chairman. Mr. Beers, as you know, H.R. 2868 requires DHS to review facilities of IST assessment. Your testimony, you mentioned that the infrastructure security compliance is responsible for implementing the CFATs, has hired in the process of over 125 people. Can you tell me how many of those 125 people who are either on board or in the process are experts in the field of chemical engineering, chemical process safety, design engineering, or occupational health? Which are only a few fields that would be required under IST. Do you have that information for us?
We have approximately, at this point in time, 130 people either on board or in the selection process. Of those, we have a number, 5 or 6, who are either civil or physical engineers or chemical engineers. We have a chemist on site, on staff, and we have several inspectors who've joined us from industry.
I have to admit, with the state of the industry right now, it's probably not a bad time to be out seeking someone with a chemical engineering degree, at least in my area. What type of expertise do you feel is necessary, DHS, to make the IST determinations?
Well, I think, as with everything we've done with the CFATS program, it needs to be an inclusive process. It needs to include industry. It needs to include DHS security expertise, which we have on staff. It needs to include academia. It needs to include the covered facilities themselves. So we envision, as we move forward, if this legislation is enacted, working with the covered community as closely as we have in standing up the CFATS program.
And that gives me some comfort. And I know you're not here representing the Coast Guard, and I have some questions regarding the Coast Guard's current security regimen under the Maritime Transportation, which has been cooperative between the industry in my area and the Coast Guard. MTSA's requirement is to prevent maritime transportation security incident, defined as any incident that results in a significant loss of life, environmental damage, transportation system disruption, or economic disruption in a particular area. Do you see this mission significantly different from what H.R. 2868 seeks to prevent in chemical facilities that may not be waterside or under MTSA?
The Secretary of Homeland Security, as she was becoming familiar with the activities of the Department of Homeland Security, was informed early on in her tenure of the potential for differing enforcement with respect to the Coast Guard's responsibilities under MTSA and the NPPD responsibilities under CFAT, and asked the Commandant of the Coast Guard and myself to ensure that we work together over the course of this year to seek full harmony in terms of the implementation between our two regulatory regimes. As a result of that, Sue, on behalf of MPPD and a senior flag officer of the Coast Guard, have a committee that has met and is in the process of trying to ensure that those two regulatory regimes are in full harmony. Sue, do you want to add anything to that?
I only have 5 minutes. Do you believe this legislation is absolutely clear that MTSA facilities will only have to deal with one federal agency or one sub-agency of DHS as a Coast Guard? And to follow up, right now, and I think a number of members have bought our TWIC card because I spend a lot of time on plant sites in our district. It kind of concerns me that a chemical worker at, say, ABC Chemical Company has Waterside uses a TWIC card, and yet if they go to their plant facility at another location that may not have Waterside, would have to have a different set of regimen. Is there any way that through this legislation or through DHS we can harmonize that so it'll just make it much more efficient, using the TWIC card as a basis?
I understand your concern, Congressman, and that is one of the areas, obviously, that we want to look very carefully at to ensure that we have, if not a single regulatory regime, at least a fully harmonized regulatory regime. Okay. That card issue is an issue that is much broader than just these two regimes as well.
Oh, I know it's, it covers not only workers. I have 5 refineries and I'd say a boatload of chemical facilities in my area, and I appreciate DHS partnering with our community over the years, both the local law enforcement and federal law enforcement, to make sure we safeguard our community. So thank you, Mr. Chairman.
Great. We thank the gentleman very much. There are 3 roll calls that we will have to attend to as members out on the House floor, and so we will take a brief recess after we recognize the gentleman from Illinois, Mr. Shimkus, for his 5 minutes of questioning.
Thank you, Mr. Chairman. And this kind of follows up to my opening statement. I appreciate you all being here. One of the comments I made was that we are talking about farms, hospitals, universities, deep underground wells, basically anyone, anywhere who possesses a quote-unquote substance of concern as defined by the legislation. At a June 29, 2009 meeting to update the Chemical Sector Security Summit, a leading official at the Department of Homeland Security stated that the department is doing targeted outreach to colleges, universities, and medical and public health facilities. Does this mean that you consider, and this is for Mr. Beers, that you consider colleges and universities to be in the high-risk tiers?
I was actually the official who made that statement, so I'll elaborate. What I was announcing is that we are beginning some targeted outreach for awareness purposes in certain segments of industry, colleges and universities and public health and healthcare facilities among them. There are currently colleges and universities and other healthcare facilities that are tiered under CFATS. We want to make sure that those communities understand the CFATS programs and their potential requirements under it, and our willingness to work with them to incorporate into their security plans their unique circumstances.
So the answer is yes.
The answer is yes, there are.
Okay. So if yes, they are tiered, and we're talking about colleges and universities, are they in Tier 1 or Tier 2?
They are in, actually, at this point in time, lower tiers, primarily 3 and 4.
Does that mean that DHS considers hospitals and other public health clinics or facilities, you're saying that they're falling into the lower risk tiers, not in the 1 and 2?
Correct.
According to this presentation, DHS considers certain federal facilities to be outliers. In Section 550 exempted many federal facilities. Since DHS is having trouble implementing Section 550 before it expires, what is the Department doing chasing entities that it considers outliers when you don't have the legal authority to do anything about it?
Well, we do have the authority to identify facilities as high risk based on other considerations than their submission of top screen. that's in our rule. What the reference to outliers was getting at was we have worked with 2 states in particular, New York and New Jersey, to have them, based on their knowledge, help us identify facilities in their jurisdictions who may have not yet filed top screen and need to do so.
Going back to the opening statement, so we've addressed hospitals and universities. What about the issue of the terminology substance of concern for farms and deep underground wells?
The current policy is that there is an extension of those entities having to file. That is ongoing.
And when will you make a determination?
We have begun a data gathering effort. We expect to be issuing some data calls to supplier firms in the not too distant future. That will be the beginning of the process of collecting information in order to make a determination. This will be all done publicly and transparently so that affected or potentially affected entities will be fully aware of what's happening.
Okay, Mr. Chairman, that's all I have. Thank you very much. Thank you for your
Time
answers.
has expired. What we're going to do right now is to take a brief recess, and we should be back here in about 15 minutes to reassemble and to continue the questioning. So the committee stands in recess. Thank you for your patience. There was an extended period of time for the roll call. Let me turn and recognize the gentle lady from California, Ms. Capps.
I'm still out of breath, Mr. Chairman.
No, good. You made the right decision, though.
I did.
Getting back here first is a big
Thank you very
payoff.
much. As has already been referenced, and this is for Undersecretary Beers again, recent events have demonstrated that we live in a world where terrorists can go to a beauty supply store in Colorado to secure chemicals for a bomb they intend to use for an attack in New York City. Incidents like this illustrate how security vulnerabilities in one place can result in injuries or deaths all the way across the country. My questions are going to be in the area of citizen suit provisions. The administration has not taken a position on this, am I right?
That is correct.
Well, I'd like to frame this in a broader context then. Do you agree that broad enforcement of CFAT's requirements is central to our security?
We certainly believe that the ability to work with industry to increase the security and safety for the country is absolutely critical. If that requires some kind of leverage, then we're prepared to consider it. Obviously, we prefer not to have to use it.
Well, let me just sort of work up to that. Is it fair to say that the department perhaps lacks all the personnel and resources to observe for all violations at all regulated facilities at all times?
I'm sorry?
Would it be fair to say that the department lacks personnel and resources to observe for violations at all regulated facilities at all times?
Oh, that goes without question. I mean, our intent is to be able to visit each of the Tier 1 sites in this fiscal year, and 50% of the Tier 2 sites based on the current resources that we have available.
Well, but that isn't everywhere at every time. I mean, that's kind of omniscience if you're able to do that. So that leads me to say, is it possible that neighbors who live around a chemical facility and observe it in their neighborhood every day may be in a position to spot evidence of security violations that the Department of Homeland Security may not be aware of on any particular day?
That is possible, yes.
Well, that's what I'm leading to in the area of concerns that many neighborhoods have raised about their opportunities to recommend and have their concerns addressed in this way. Can I ask you what you feel should be done about this?
Well, we have a system now in which citizens can report their issues or concerns to the Department of Homeland Security, and it appears at this particular point in time to be working. I mean, Sue, you want to add anything?
I guess yes, and I would like to add, what are the steps that are taken and what kind of guarantee that would neighbors have that there would be the kind of follow-up that they would know about, too?
Well, what we've done in CFAT's implementation is to, number one, have a very publicly accessible website where people can get information about the program. It's a subset of the DHS main website, and we've also established a tip line where an individual can either call anonymously or call and identify themselves if they would like to be contacted in follow-up to report any kind of security concern.
Would they have any assurance, or is there any feedback? Is there a procedure that then that they know that this is being addressed?
Well, if they identify themselves and request follow-up, one of our staff will get back to them.
And is there a record of this having happened?
Yes.
So that it's possible that there is a record of citizens. So how about if they're not satisfied with the answer? Is there a possibility for legal action?
At this particular point in time, they can certainly go to you as their congressperson or to someone like that. But we're dealing with information here in some cases where the information that's relevant to the decision that we might take for inaction or different action from what they were suggesting or requesting we're not in a position to reveal to them the basis for which we would undertake to act differently than they thought we ought to act.
So if they feel that their reporting has not been followed up upon to their satisfaction, they have no further recourse at this time?
They can come to you.
They can come to their member of Congress. Well, I'm not going to pursue it any further, but this committee, as it has a long history with citizen enforcement and citizen suit provisions. For close to 40 years, this committee has included citizen enforcement provisions in each of our environmental laws, from the Clean Air Act to the Safe Drinking Water Act. And we have now ascertained that this is a valuable tool in enforcing our laws. I appreciate your thoughts on this matter. Thank you very much, Mr. Chairman.
Thank you. The gentlelady's time has expired. The chair recognizes himself for 5 minutes. 7 minutes. Thank you. Mr. Silva, I just want to say my father's a civil engineer, and I appreciate the work civil engineers do to make our country work, and this is certainly an important part of it. In your testimony, you mentioned that there was a security gap, or that a security gap exists. I'm going to ask you sort of an open-ended question here. What is not part of the security gap? In other words, what do you feel good about in terms of the security of our nation's water supplies?
Well, right now, I think that the gap exists in terms of the fact that we don't have coverage in both the water and wastewater sectors. And so with this bill, and hopefully with further action by the committee, as was mentioned, EPA would take the lead in ensuring that those two sectors would be covered for security purposes.
Okay, but is there anything you feel good about in terms of what part of our water infrastructure do you feel is secure and we don't need to worry too much about in terms of terrorist attack or so on?
Well, again, right now we do have existing site security plans and assessments that we do as part of the Safe Drinking Water Act. But again, we feel that there could be a gap, and so that we would feel more comfortable working with DHS to ensure that all facilities are covered, and if there are more of the Tier 1 and Tier 2 type facilities out there, that they can be covered under this.
All right. What are some of the more significant challenges that the EPA might face in meeting the obligations under this legislation, and do you think that they're adequately addressed in H.R. 3258?
Well, I think some of the more principal ones probably would be funding for communities, one to perform the inspections, to do the plans, and also to carry out any kind of changes that would come out of any IST type of a review. And so we feel comfortable if we get the legislation through and we have the funding that's available in the legislation, that we could work with states and communities to fund those types of requirements.
So you don't have any particular recommendations then on improving the legislation?
Well, no, again, the recommendation would be, again, to be able to cover both water and wastewater. And somehow get those two under the same umbrella through EPA, again, working with DHS.
Okay, you did mention that in your earlier testimony. I appreciate that. Mr. Beers, I'm going to follow up on a question that Mr. Markey asked, or a similar question regarding exemptions for small businesses. And I understand the need for small businesses to be able to move forward and work without too much hindrance, but I see a potential for a significant risk with regard to small business in terms of risk to the population. How can you address that?
As I tried to convey, we have a process that currently exists in which we are prepared to work with each of the facilities that are covered for them to present their assessments, to work with them with respect to their development of responses and plans, in order that we can do this in a way that both protects public safety and security and at the same time doesn't undermine the economic viability of the small business concern. My point earlier, though, was this is not an issue of defining whether the risk is less important because the size of the firm is small. The risk doesn't change.
Correct.
With respect to the size of the firm.
Well, earlier, I think the testimony was that there are 6,156 facilities. I think that was the number that was given. That's a large number. Do you feel that this legislation will increase the risk of layoffs or some of these facilities closing because of regulatory burdens that are being placed on them by this legislation?
It is certainly not our intention to enforce any legislation that Congress should pass that would automatically have that effect. We will try to work with all of the concerned facilities not to have that kind of an economic impact. That's certainly where we start from.
Okay, and you, Mr. Silva and Mr. Beers, you see opportunity for cooperation between your two agencies. There's not too much reason why there wouldn't be any hurdles or personalities that will cause problems in enforcing this new legislation.
One of the, I think, benefits of the process with respect to working with this committee is the agreement that our two agencies have come to think through how we would work together and cooperate. Obviously, the devil's in the details, and we'll have some other issues that we'll want to have to work through, but I think we've got a really solid start here to an ability to work together with EPA and the league.
I would definitely concur with that.
All right. Well, thank you. That's all of the questions I have. Mr. Upton, do you have any additional questions?
I just want to say, I know Dr. Burgess had some questions, and he had they have a weekly Texas meeting, Texas delegation lunch, and I might just ask that we keep the record open for questions from members that did not come back, so that we might be able to forward those questions to both of you for a response and allow that to be placed into the record, if I might.
Okay, without objection.
Yeah, no one's here to object.
Yeah. Okay.
Going once.
Excuse me, that concludes our first panel.
Thank you. Thank you.
Thank you.
Thank you for coming out here to testify today, and you're going to stick around for a few minutes to see if Dr. Burgess has questions? Well, we now welcome the second panel, starting with Brian Ramaley. Did I pronounce that correctly? Mr. Ramaley serves as president of the Association of Metropolitan Water Agencies, the AMWA, which is an organization representing the largest publicly owned drinking water providers in the United States. Mr. Ramaley is also a director of the Newport News Waterworks in Newport News, Virginia, which provides drinking water to more than 400,000 customers. He previously served as chairman of EPA's National Drinking Water Advisory Council from 2004 to 2007. Thank you, Mr. Ramaley. Martin Durbin, who is vice president of the Federal Affairs for the American Chemistry Council, where he is responsible for directing federal legislative advocacy. In his previous tenure leading the ACC's security program, Mr. Durbin was responsible for public policy, advocacy, communications, and operational activities of the association as related to site, cyber, and value chain security for the business of chemistry. Welcome aboard. Thank you for coming. Darius D. Sivan, did I pronounce that correctly? Darius? Dr. Darius D. Sivan. Dr. Darius Sivan served as the legislative representative for the International Union, UAW, since November 2007. His work with the UAW includes 5 years in the UAW Health and Safety Department, where he conducted numerous workplace entries to investigate health and safety issues at a wide variety of facilities. Prior to joining the UAW, he was employed by the Occupational Safety and Hazard Administration and by the Washington State OSHA program. Dr. Sivan received his Ph.D. in Environmental and Occupational Health from the Johns Hopkins School of Public Health and his Master's in Environmental Studies from Evergreen State College. Thank you for participating. Stephen Porman. Mr. Porman presently serves as the Manager of Environmental Health, Safety, and Security for the Fujifilm Imaging Colorants. He also chairs the Society of Chemical Manufacturing Affiliates Safety and Security Committee and has been actively involved in the chemical security issues while serving in this capacity. Mr. Porman's previous experience includes service as a program supervisor at the Ohio Environmental Protection Agency and EHS manager with responsibility for chemical security at chemical manufacturing sites and corporate headquarters. Thank you for participating. We'll begin our panel's testimony with Mr. Ramaley. You have approximately 5 minutes. Begin when you're ready.
It's not on.
Now it's on. Yes. Good afternoon, Mr. Chairman and members of the committee. My name is Brian Ramaley, and I am the director of Newport News Waterworks, which, as you indicated, provides drinking water to more than 400,000 people each day in southeastern Virginia. I'm also the president of the Association of Metropolitan Water Agencies, or AMWA, an organization that represents the largest publicly owned drinking water providers in the United States. In my testimony today, I'm going to focus on H.R. 3258, the Drinking Water System Security Act. AMWA understands that H.R. 2868, the Chemical Facility Anti-Terrorism Act, is not intended to apply to drinking water systems. However, we opposed similar legislation last year, H.R. 5577, that would have subjected drinking water systems to federally mandated inherently safer technologies through the DHS CFATS program, and we would do so again this year if such a bill were proposed. Turning to the Drinking Water System Security Act, while H.R. 3258 is not perfect, there are several components of the bill that enable AMWA to offer its support for that legislation. First, it continues EPA's regulation of drinking water system security, thus avoiding duplicative requirements with DHS. Second, the bill maintains the important concept of local choice in water disinfectant and does not allow EPA or any other federal entity to broadly force drinking water systems across the country to change their disinfection methods or chemicals. Instead, the bill requires drinking water systems that employ certain chemicals to evaluate the feasibility of potential IST options and decide on their own whether the utility will begin using those alternates in the future. Only a state drinking water agency, enforcement agency, not EPA, is given a direct opportunity to review a utility's analysis and mandate a change in disinfectants after considering factors such as feasibility, cost, and possible water quality implications. I must point out that AMWA's acceptance of this state-level review is based on our expectation and experience that state drinking water enforcement agencies which have an awareness of local water utility operations will act responsibly when reviewing a utility's disinfectant choice. AMWA could not support this approach if EPA or another federal agency had the direct ability to dictate a state or local water disinfection decision. Additionally, the bill reflects AMWA's request that the current criminal penalties, I should say, of up to 1 year in prison and substantial fines be maintained for individuals found to have unlawfully distributed protected utility information. Any weakening of the penalties for the unlawful disclosure of protected information would increase the chances of an unauthorized leak of sensitive utility security documents, and such a leak could provide terrorists and criminals with a detailed account of where and precisely how a utility's security could best be compromised. The legislation does direct EPA to formulate standards to facilitate the appropriate sharing of protected information with entities such as local first responders, certain water utility employees, and their union representatives. AMWA looks forward to participating in EPA's development of standards that will set the ground rules for how this information may be accessed. Some suggested improvements. AMWA hopes to continue working with the committee and other members of Congress to further strengthen H.R. 3258. For example, the legislation should include an appeals process that a utility may initiate if they disagree with their primacy state agency's order to adopt an alternate water disinfection method. Because the decision on water disinfectants is so critical to public health and public health protection, I believe the opportunity to be heard in an appeal process is a reasonable request. AMWA also remains concerned that the legislation would apply only to the nation's drinking water systems. While H.R. 2868, as approved by the House Homeland Security Committee, would regulate the security of wastewater utilities under DHS CFAT's program. I think we've heard here today that there is some agreement that that should fall under EPA as well. This approach would be especially problematic for municipalities that operate both water and wastewater systems, as do many AMWA members, as it would force the employees of such systems to comply with two varying sets of security rules issued by two different federal entities. To resolve this issue, AMWA recommends and supports that the security of wastewater utilities be regulated under the same EPA program that this legislation would apply to drinking water systems, and that both drinking water and wastewater utilities remain explicitly exempt from CFATs. In closing, I want to thank the committee for working with AMWA on H.R. 3258. Because of the improvements made to the bill, AMWA is pleased to offer its support and hopes to continue to work with the committee to further strengthen the bill in the weeks and months ahead. That concludes my testimony, and I'll defer answering questions until the rest of the panel speaks, if that's your choice.
Thank you, Mr. Ramaley. Mr. Durbin, you may begin.
Mr. Chairman, Mr. Upton, thank you very much for the opportunity to again speak with you on behalf of this very important subject, on behalf of the members of the American Chemistry Council. Having worked on this issue for 8 years and testified before Congress on numerous occasions, I know that this issue is always accompanied by heated rhetoric and emotion, regardless of what I consider to be significant actions taken by all those involved and enormous progress that's been made. So while there are clearly differences on how best to achieve the objectives of securing our nation's chemical facilities, I think it's useful to reflect on what has been accomplished. First, after September 11th, ACC and many others in the chemical industry stepped up and implemented serious, stringent security programs at their facilities before there was any specific government direction. Second, Congress stepped in and enacted national legislation to ensure that these assets, their workers, and the communities where they operate are protected. And third, DHS has acted swiftly to develop and implement comprehensive security regulations. CFATS is by far the most robust, comprehensive, and demanding chemical security program to date, and DHS should be commended. ACC believes CFATS provides a solid foundation and that Congress should provide DHS the necessary staff and resources to ensure continued success. As Congress now analyzes CFATS and identifies areas for improvement, ACC is committed to being a constructive partner. While our views are not always in alignment, I want to acknowledge the willingness of the Energy and Commerce Committee and its staff to seek our input and consider our viewpoint. We've had constructive discussions, and we hope to continue working together to make a smart regulatory program even better. I believe our common goal is greater than our differences. Now, ACC's record of accomplishment and cooperation with Congress, DHS, and other agencies is well established. Since 2001, our members have invested nearly $8 billion in security enhancements under our own Responsible Care Security Code, and we continue to support strong federal chemical security regulations. Our security code not only provided a model for chemical security programs in New Jersey, New York, and Maryland, it was also recognized as an alternative security plan under the U.S. Coast Guard's Maritime Transportation Security Program. Turning to the DHS program, at each step of the regulatory development process, our members volunteered to pilot core program elements and assist DHS in rapidly and successfully developing the tools needed to implement the program and swiftly meet their deadlines. CFATS is a tough yet flexible program that allows facilities to utilize a full range of potential security enhancements, including inherently safer approaches to address potential security vulnerabilities. This is exactly what a strong, smart regulatory approach must do: set a high bar through performance-based standards and then hold facilities accountable. The legislation being considered today by this committee represents an important step toward making CFATS permanent. We're pleased to see H.R. 2868 reflect many of the security measures that will be implemented under CFATS, and we appreciate the efforts made to minimize duplication of effort by facilities that have already acted or will take further action under the program. However, I would like to highlight just a few provisions we've discussed with the committee where our members continue to have questions and concerns. For example, we believe the provision that would give DHS authority to mandate process changes is unnecessary. Through its use of risk-based performance standards, CFATS drives each facility to consider all possible risk reduction options, including inherently safer approaches, while developing a site security plan. While you can't mandate innovation, CFATS does allow DHS to unleash the ingenuity, expertise, and resources of the chemical sector. In addition, we feel the provision that provides for private right of action is counterproductive to the ultimate success of CFATS. Unlike environmental statutes, CFATS is not a series of prescriptive statutory measures like emission standards or discharge limitations. It will therefore be difficult for a citizen or judge to ascertain if a standard is being met or to decide what needs to be done to address an alleged deficiency. However, let me be clear that we fully support strong enforcement, so we would again urge Congress to provide DHS with the necessary tools and resources to ensure compliance. Also, since employees are the first line of defense when it comes to chemical security, we appreciate provisions that address employee involvement. One of the core components of ACC's Responsible Care Security Code stresses employee involvement, including training, drills, and guidance. So we would like to continue to work with the committee to ensure that the right people with the right knowledge are involved in our efforts to secure chemical facilities. The crucial partnership between our industry and the federal government requires each of us to do our part. ACC and its member companies are committed to safeguarding America's chemical facilities, and we will continue to work with Congress and DHS in that spirit. Thank you.
Thank you, Mr. Durbin. Mr. Sivan, would you please begin your testimony? Now, we just got called, so we have about 10 or 15 minutes before we need to leave, so there's plenty of time.
Mr. Chairman, Ranking Member Upton, members of the subcommittee, thank you for the opportunity to testify today. I am Dr. Darius Sivan, representing the CWA-UAW Legislative Alliance. We represent more than 2 million active and retired workers who are members of the Communications Workers of America and of the International Union UAW. Both unions represent members who work at facilities potentially covered by the legislation before us today. The CWA and the UAW strongly support H.R. 2868, the Chemical Facility Anti-Terrorism Act of 2009, and H.R. 3258, the Drinking Water System Security Act of 2009. We urge the subcommittee and the entire House to grant prompt and favorable consideration to these two bills. We would not like to see delay beyond the one-year reauthorization already in process. We have heard how enhancing the regulation now might strand some sunk costs. Additional delay will offer the opportunity for further costs, which would ultimately be sunk and stranded. Chemical security is an issue of great importance to organized labor because our members get hurt first and worst in case of any attack. CWA and UAW believe that government should have the authority to require the higher risk tiers to implement their own plans to reduce the consequences of an attack. We have heard examples supposedly of how this would result in bad solutions being imposed on industries that would increase risk. We disagree because the language of the bill clearly says that a solution cannot be imposed unless it would reduce risk. The only thing that would have to happen is a facility would have to submit an analysis showing that a solution would not increase risk. and then they would not reduce risk, and then they would not have to implement it. We are very pleased that members on both sides of the aisle are concerned about protecting our jobs. Nothing is more important to the men and the women of the labor movement than the protection of jobs. We want to make it clear that we do not believe that anything in the MRC provisions of this legislation, H.R. 2868, as introduced, is a threat to jobs. There does not need to be any additional requirement for analysis or administrative law review to protect jobs. We think that the addition of additional requirements to the bill as introduced would only make it harder to implement necessary security measures and would not add any protection of jobs. Further, we would like to strongly support Undersecretary Beer's statement that the size of the risk is not related to the size of the business. We would like the subcommittee to move very, very carefully if it seeks to protect small businesses. For example, using the Small Businesses Administration's definition of a small business could exempt very high-risk facilities, including one that puts 12 million people at risk. We think it's very important that government be able to give weight to the degree of the security risk as well as the size of the security. We are quite concerned about some of the background checks because we think they could provide an opportunity for rare but very real unscrupulous employers to go on fishing expeditions, and if a fishing expedition is undertaken in the name of security, it would be very difficult to question it. We would like to see the following improvements made to H.R. 2868. First, adverse employment decisions should be made only pursuant to a determination by DHS that an individual's offenses could cause the individual to be a terrorism security risk. Second, employees subject to adverse employment decisions should be informed of the basis of the decision and that they have a right to appeal and or file for a waiver as provided by H.R. 2868. Third, any employee subject to an adverse employment decision should have the option to exercise any rights they have under a collective bargaining agreement without losing the right to appeal. We are pleased with the language that supports participation of employee representatives in both bills. We would like to see in the water bill the additional thing whereby employee representatives would have a right to a copy of the MRC provisions after they are jointly developed. And we do not believe there should be any additional stipulations as to how employee representatives should be chosen, and we do not believe employee representatives should be subject to criminal penalties for disclosing vulnerability information to those who have a legitimate role in fixing problems. We think that H.R. 2868 should be amended to give employees and their representatives the right to accompany an inspection similar to that which they have under OSHA. We also believe that to develop public confidence, there needs to be additional information made available to the public to allow for government accountability for enforcement. Finally, I want to reiterate that we support favorable action on both these bills, and we look forward to continuing to work with the committee to improve them. Thank you on behalf of the Communications Workers of America and the International Union UAW.
Okay, well, thank you so much. And we have time to get in the final opening statement of our witnesses, Mr. Poorman, and then we're going to recess again to attend to the roll calls on the House floor, and we will then return to complete the session. So whenever you're ready, please begin.
Good afternoon, Chairman Markey, Ranking Member Upton, members of the subcommittee. I'm pleased to testify before you regarding H.R. 2868, the Chemical Facility Anti-Terrorism Act of 2009. I speak today on behalf of the Society of Chemical Manufacturers and Affiliates. SOCMA represents the batch and custom chemical manufacturing industry. Over 70% of SOCMA's members are small businesses that employ more than 100,000 workers nationwide. From pharmaceuticals to cosmetics, soaps to plastics, and all manner of industrial and construction products, SOCMA members make materials that save lives, make our food supply safe and abundant, and enable the manufacture of literally thousands of other products. For over 88 years, SOCMA has partnered with the federal, state, and local governments to protect America's critical infrastructure. SOCMA encourages Congress to make the current risk-based CFATS program permanent, or at least to reauthorize it for another year. The CFATS program protects our nation from terrorist attacks by requiring thousands of chemical facilities nationwide to deploy hardened security measures. Our members have spent billions of dollars before and now under CFATS to secure their facilities and operations. We support those aspects of H.R. 2868 that would codify the current CFATS program, but we have serious concerns about two aspects of the bill: the requirement for mandatory implementation of inherently safer technology and the citizen suit provision. These provisions are inherently unwise and potentially counterproductive to our shared goal of preventing terrorist incidents. They would slow and possibly undo the progress that industry and DHS have made thus far. First, inherent safety is not a simple technology or fix, despite what you may hear today. Inherent safety is a philosophy by which engineers, operators, and management work together to reduce the level of risk that may be associated with a chemical process life cycle. Inherent safety analysis must be conducted very thoughtfully by people who understand the process. Empowering even well-intentioned regulators to second-guess the judgments of the engineers who know their processes best could result in actually increasing or transferring overall risks. It could also wreak economic havoc on regulated facilities, especially small businesses. Makers of active pharmaceutical ingredients and other federally regulated substances would be most at risk. For example, one SOCMA member is a small business regulated under both CFATS and the rules of the Food and Drug Administration. This company produces an active pharmaceutical ingredient used in the treatment of life-threatening bacterial infections. If a mandated safer manufacturing process was outside the terms of the FDA's approval, the company would likely be forced to discontinue production, lay off workers, and increase our nation's vulnerability to grave health threats. Production of that crucial ingredient would likely shift to foreign countries where FDA is less able to monitor quality standards. The world's experts in chemical engineering have told Congress that there is no consensus methodology to measure whether one process is inherently safer than another. For this reason and others, they have consistently recommended against regulating inherent safety for security purposes. Today, the administration now supports mandating IST for Tier 1 and Tier 2 facilities when unspecified key criteria are met. We acknowledge that DHS officials are sincerely trying to do their very best under ever-mounting political pressure, but it is imperative for Congress to listen to chemical engineers and not political scientists. Consistent with the experts' recommendations, Congress should direct DHS to submit to a report that explains in detail how DHS intends to compare various IST alternatives. Such a report should be developed with broad participation by the expert community and stakeholders. DHS should be allowed to focus all its other resources on completing the current CFATS program. Secondly, we strongly oppose applying environmental law citizen suit provisions to security laws. We are concerned that no matter what protections courts impose, sensitive security information inevitably will be disclosed and could be used by terrorists to target a facility and its surrounding communities. A citizen suit provision will also divert needed resources from DHS's efforts to finish implementing and enforcing CFATS. If people believe they see security weaknesses, they have effective options now, such as calling the CFATS tip line at 1-877-FYI-4-DHS. Again, SOCMA supports permanent risk-based chemical site security standards, and we urge Congress to authorize the existing CFATS program. I look forward to your questions.
Great. Thank you so much, Mr. Pullman. So, again, we apologize. We'll have to take a recess for why don't we schedule about 15 minutes from now, where we'll come back. I think it will be 15 minutes this time. The committee stands in recess.
Basically, since I got to the legislative office, he didn't stop. Almost all. It would have been gavel. Yeah, I think I meant to. at the hearing a year ago. It was a different subcommittee. They recombined subcommittees, but it was basically the similar experience. Yes.
They'll be,
Andrew Taylor, also formerly of the UAW Health Association.
I always
He's a professor at Morgan State.
Who are you looking at? Well, it's really too bad that Gene didn't buy it, because he could have asked more serious questions. I absolutely.
Okay. Thank you.
Oh, there's my picture.
That's totally fine. Email me the picture.
You started a trend.
Did
you get that Mr. Foreman in there too? Yeah.
Or just, you want to... There's the vote thing.
Yeah. I'm in there a little bit, enough. Obviously that wasn't good. Oh, you got it.
That would be lovely.
I want an action photo.
Oh, it's in the it's like right below us. I think the basement is.
I didn't do it.
Yeah, one floor below.
Welcome back, everyone, and we apologize for having the United States House of Representatives meet simultaneously with this hearing. It is an unavoidable conflict that, unfortunately, is characteristic of my life, meaning 33 years in the institution. It would be so much better if they would plan their lives around ours rather than the other way around, but like so many other things in life, as William Shakespeare said, the will is infinite, but the execution is confined. And so we're confined by these roll calls on the House floor, and we return here to complete the hearing with our gratitude to the witnesses and to everyone else, the remaindermen of history who are still sitting out in our audience, and whatever C-SPAN audience we still have left for this vitally important issue. There is kind of a get-a-life quality to this hearing at this point, and for anyone who is still watching, and we appreciate the attention which is being paid by whoever is out there in a non-somnambulant state. So let us turn to this point. Let me recognize the ranking member, Mr. Upton, if he would like to ask his questions at this time.
Well, great. Well, thank you, Mr. Chairman. I do have a number of questions. First, I'd like to put a couple of letters into the record to ask unanimous consent that happen.
Without objection?
I have a number of questions, and I talked to a number of members on the Homeland Security Committee during this last series of votes, and I know that they've marked up their bill earlier this year, and I don't know if we have a date of when you're thinking about what the next step is. But the questions that I have do relate to the economic consideration of these facilities, and I accept the statement that was made on the last panel. Mr. Durbin, if is your read of this bill, what does this do to your membership? Do we see, as some have suggested, that a number of companies will pull up stakes and go someplace else? What is the economic impact as it relates to jobs? And certainly I want these jobs to stay here, but what is your sense as you've talked to your members?
Well, Mr. Upton, let me take a step back first and let you know what our member companies have done to date. Because I mean, they really looked at the issue of security at their facilities as their responsibility and a cost of doing business, and to date have already, before having to implement under CFATS, have invested $8 billion to enhance security at their facilities, and we represent roughly 2,000 facilities around the country. So these are obviously investments that have already been made. We do expect that the CFATS program will require some additional investment. There's kind of hard to put a number on exactly what that will be. DHS in some of their earlier testimony have estimated an additional $8 billion across the industry, across all of the regulated facilities to implement CFATS. But as far as what additional costs will come about through CFATS or through this bill, again, those decisions, many of those investment decisions have been made, are being made, and have been part of the plan. The extent to which additional requirements might add to that, I mean, I can't say that they won't. I think it certainly is going to. There will be more resources that will have to be put into further analysis and potentially further investments. But again, I don't. At this point, there's no way of quantifying. Here's what the cost will be, or here's how many facilities will or will not end up having to make significant changes or consider not operating anymore.
Mr. Poorman, you ended your testimony talking about these citizen lawsuits and the potential for what is pretty secure information relating to the security of these facilities to be, in fact, opened up. Is that right?
Yes. That's the concern that we have is that the information that is put into DHS through their secure information systems would be leaked out and could get into the wrong hands and create situations that obviously would not be desirable.
Is any of that information now available to folks? I mean, in terms of security relating to any of these thousands of facilities that are out there, is it pretty difficult to to be able to obtain at this point?
Yes, it is. And it's been that way even since when we did other pieces of legislation and regulatory programs, such as RMP. The Justice Department made sure that that information was protected as well, because it does have a security aspect.
Dr. Sivan, is the UAW or the communication workers taking a position as it relates to the release of information as to the secure aspects of those facilities? Do they have a position on that part of this bill?
If you mean facility-specific information, such as that contained in security vulnerability assessments and site security plans, the only people we favor having access to that information are those employees and their representatives who participate in developing those plans. If you mean other types of government accountability information, such as is a particular facility covered by the statute and the regulations, in a general sense, is it in compliance? We believe that the public at large needs to have that kind of information in order to know that all responsible parties are doing their jobs.
Dr. Durbin, I know my time is expiring rapidly here, but is it your sense that if this bill were to move forward ultimately to the President's desk, what impact would it have on your membership in terms of being able to continue to operate as they are doing now? Do you think that this, in fact, would provide as an incentive for companies to move someplace else outside of the United States borders?
Reading from the language of the bill, sir, reading from the language of the bill, it says that the Secretary of Homeland Security must show that implementation of methods to reduce the consequences of a terrorist attack would not significantly and demonstrably impair the ability of the owner or operator of the covered chemical facility to continue the business of the facility at its location. That is to say, if a facility could show that it would have to move from Adrian, Michigan to Toledo, Ohio, the Secretary of Homeland Security has no authority to require implementation. And certainly if a facility could show that it would have to close its doors. Therefore, I expect zero impact on employment.
Dr. Durbin, do you accept that?
Well, thank you for promoting me to a doctor.
Oh, I'm sorry.
That's quite all right.
Sorry.
But no, in general, excuse me. I would just say I think that again there are provisions in the bill that we continue to have concerns with that we think would be more difficult to operate. And as I mentioned in my testimony about the civil lawsuits and the and the IST provisions. However, we are eager and anxious to continue working with the committee to make changes to the bill as it moves forward.
Okay. Thank you. You bet.
Great. You didn't just call him Mr. Chairman by accident quickly, did you? Because the fact that he can make you a phony doctor can't make him.
Yeah.
It doesn't. They can't. You know what I'm saying? It's just
once the chairman, always the chairman. Isn't that what it is?
Let me turn and recognize the gentleman from Texas, Mr. Green.
Thank you, Mr. Chairman. And I always heard when I was a state legislator is once a state senator, always a state senator. But I don't get called that in Austin, in D.C. very much, only in Austin. Mr. Durbin, H.R. 2868, you mentioned in your testimony, has civil suits for uninjured parties and it's interested in DHS. And in my opening statement, you may have heard that I have some concern about that. Would you feel more comfortable if we actually limited someone who could show harm, whether it be an employee or a neighbor, similar to what current law is, on someone who actually be harmed?
I think that's certainly true. That I think one of the complications you have is being able to show harm under a security statute as opposed to environmental statutes, as we've discussed before. But certainly finding ways of limiting the applicability is going to improve that.
Well, and maybe you can comment, because I'm familiar with our public's right to know statutes, that all my plants have their SARE committees that they meet with, and I don't have any problem with plants and people who live near the plants or work there knowing what's going on. I do have some problem with someone across the world or somewhere else who really shouldn't be interested in what's going on in a chemical plant or refinery in my district. But the folks who live there because the security issue. That's why I know the security issue is something just, we had to deal with that after 9/11, that we wanted, in fact, we crafted legislation to show that someone living there had that right, but someone in a cave in Afghanistan, looking on the internet shouldn't have that capability. And so that's why hopefully we'll be able to deal with that in this bill. I know sometimes IST is confused as a new concept, but that, inherently safer technology has been around for many years, and I know most businesses in production or manufacturing use that. In the chemical industry, is the chemical industry opposed to legislation that require companies to assess IST?
Well, again, I will only speak for ACC. I think because ACC members are already required to assess inherent safety in their own operations under the security code, under the process safety code that existed prior to 9/11, and I would hasten to add that in the state of New Jersey, they require consideration of IST. We operate, our companies operate there as well. That program, frankly, has been very effective. That ACC members would be comfortable with the requirement to consider. Because again, I would also say we think that the regulations as they are today, when you're trying to meet performance-based standards, you're going to have to consider all the options on the table.
Well, and I know New Jersey has the state does mandate, the state of New Jersey doesn't have where they can mandate the IST. They just mandate the consideration.
Correct.
Okay. Dr. Stephen, in your testimony, several recommendations you believe on the importance to approve the legislation, particularly in the background checks. Can you elaborate on your suggestion that the bill should codify statutory language that protects individuals who have fully equivalent federal background check? And you heard my comments earlier. If I have a plant that has, is under maritime, and they have the TWIC card, Transport Worker Identification Card, and yet they have a plant that's not covered by that, would you feel comfortable that the TWIC card or that background check for the TWIC card should also stand in the place of the what's now CFATS or this legislation?
Sir, that's precisely the kind of thing we were thinking. If someone has already undergone a background check and has a TWIC card, and let's say they're transferred from the plant with the waterfront to the other plant, we think since they've already undergone a background check, they shouldn't have to undergo another one under CFATS. That is exactly the kind of thing we were thinking of. So I would hope this legislation would give that guidance to Homeland Security, because they're actually the same agency. I mean, Coast Guard obviously works with Homeland Security, and like I said, in our district in Houston, literally after 9/11, if we didn't have Homeland Security partnering with us with our the Port of Houston, our local law enforcement, federal law enforcement, and our refinery and chemical industry, we wouldn't be near as safe as we are today, because there's been a great cooperation in East Harris County on what we try to do for, obviously for the folks who live and work there. Mr. Ramaley, I've heard concerns from drinking water systems about unfunded mandates that could arise from this bill. If the state regulatory agency directs a drinking water system to implement IST, do you feel the legislation provides enough assistance to water systems to defray the cost of any of the inherently safer technology requirements?
I think you're asking me if I would consider the imposition of IST on water and wastewater utilities an unfunded mandate. And at this stage, I'm not aware of programs that would provide money to water utilities for making technology switches to accommodate chemical changes and things like that. So, yes, it will have some impact, and I don't believe that there is adequate funding. I know there's not adequate funding to cover those costs at some of the nation's largest drinking water utilities, where those costs would be significant.
And I've shared this concern with a lot of other folks that, I have the city of Houston, part of the city of Houston, which is a huge water supplier. But I also have very small water suppliers, some of my smaller communities. And the city of Houston may be able to do some of the things, but some of my smaller suppliers can't do it because their tax base is not near as large as the city of Houston. Let me, in your testimony, you mentioned the EPA should be the lead agency for chemical security on both drinking water and wastewater. And the two pieces before us today place drinking water systems under EPA and wastewater systems under DHS. how many facilities nationwide have joint drinking wastewater systems, and what kind of regulatory burden would rise if these facilities are shifted to two different security regimens?
I can't give you a precise number, but I can tell you that many municipalities around America operate both the water and the wastewater facilities. My guess would be tens of thousands.
And I know in my area, everyone who has, you know, we may have a freshwater district that may not have wastewater, but the municipalities all do it themselves.
Many of the very large and countless small cities and towns have both water and wastewater operations. What was the second part of your question?
Well, what regulatory burden would arise with these facilities being subject to two different security regimens? You know, what EPA may require as compared to the Department of Homeland Security.
In those situations where you have utilities, municipal utilities in particular, that are both responsible for both facilities, you would have to have staff trained in both sets of procedures. There are other complicating factors as well. For example, the information sharing and analysis center that both water and wastewater facilities depend on for security information would have to be up to speed in both the DHS and EPA requirements to provide that information because that is shared and accessed by both water and wastewater systems. So there's a number of complicating factors: personnel training, investments, different procedures. There's quite a few complications.
Mr. Chairman, I know you've been patient, and thank you.
No, thank you. I thank the gentleman very much, and the chair will recognize himself for some questions. And I'll just begin by pointing out that on page 40 of the bill, in dealing with the handling of sensitive information in judicial proceedings, that on page 40 it says, in a proceeding under this title, protected information described in subsection G or related vulnerability or security information shall be treated in any judicial or administrative action in a manner consistent with the treatment of sensitive security information under Section 525 of the Department of Homeland Security Appropriations Act of 2007. In other words, those are the protections that in 2006 were put in by the Republican Congress and signed by George Bush. So the provision actually states that that should be the standard, and I think that was a good standard that we agreed upon in a bipartisan fashion back then, and I just wanted to make sure that everyone understood that those safeguards will still be in place, because it seems that there's a little bit of confusion on that. I would also add that we just talked about funds for implementing IST, and on page 36 of the legislation, we authorize $125 million for the EPA to be able to ensure that there are grants to water systems to assist them with cost, as well as more funds for other costs of compliance. So just want to make sure that everyone understands that is also in the legislation. Mr. Ramaley?
Yeah, I would just comment, $125 million spread over the nation's largest water and wastewater utility systems, in my opinion, would not go very far, but I appreciate that information.
Well, you know, we've looked at the question. We think that, you know, can do the job, and so that's, you know, that's our perspective on it. But you know, we can continue to talk about this in terms of what proper funding is. As you know, I've been a longstanding advocate for the use of inherently safer technologies. I've spent the last 5 years attempting to ensure that comprehensive chemical security legislation includes language that reduces the consequences of terrorist attack by requiring facilities to switch to safer chemicals or processes when it is economically and technologically possible for them to do so. And I met many of you during my 6 years on the Homeland Security committee, making the amendments on IST, and making the amendments on water safety and all of it down the line. So we have a long relationship at this point since 9/11 with my membership on the Homeland Security Committee. So I would like to thank all of you for being here and for your colleague Judah Prero for all of your work and efforts on trying to narrow differences and to come up with potential solutions. And I want to continue to work with you towards that goal. First of all, isn't it true that all ACC companies are required to assess already whether they could utilize safer chemicals or processes under your responsible care code, and that the American Chemical Council, therefore, is supportive of including that requirement in the legislation?
Mr. Chairman, first of all, let me also acknowledge what a great discussion we've had with your staff as well, and I think we've been able to make some real progress trying to find some common ground. But as I was saying to Mr. Green as well, yes, within the ACC security code, member companies do have to analyze inherent safety as they're doing vulnerability assessments and putting their plans together, and also in the state of New Jersey are operating under a program where they are required to consider IST. And that program is considered to be working very effectively, and the state of New Jersey, I think, would tell you the same. So, yes, our membership at this point is comfortable with the idea of a mandatory consideration of IST as we are already doing it.
Thank you. The Department of Homeland Security puts facilities into different risk-based tiers based on the type of risk the chemicals at the facilities pose. If the chemicals are highly toxic and the facility is located in a densely populated area, the facility would be tiered because an attack to cause the release of those chemicals might be the greatest risk. If the chemicals are highly toxic, but the facility isn't located near any residential community, the facility would be tiered because a terrorist would be more likely to steal those chemicals and blow them up somewhere else. Do you think that we should be looking at the type of risk that facilities pose as we consider which facilities should be subject to authority to mandate the use of safer chemicals or processes? Mr. Durbin.
Yes, in general, ACC members would clearly say that risk should always be used to help determine the priority levels of which facilities should be taking which actions.
Do you agree with that, Mr. Pullman?
Yes, we do agree with that.
Okay, Dr. Sivan? Yes. And Mr. Ramaley? Yes. Great, thank you. So I think it makes a lot of sense to look at risk, obviously, and that will, help us then to obviously put different facilities in the correct tiers. Do you think that limiting the authority to mandate the use of safer chemicals or processes to the Tier 1 and 2 facilities that have been deemed by DHS to pose a risk of a chemical release might be a more targeted way for Congress to proceed? Mr. Durbin.
Well, again, as the administration has now made very clear that they are going to, they have taken a position in favor of having some limited, IST mandate on implementation. We certainly want to continue to be part of the discussion on how best to do that. So, yes, by limiting it in that way, that would certainly be a more focused way of getting to that solution.
And we want to work with you and all the other parties here to make sure that we accomplish that goal. During the Homeland Security Committee markup, an amendment was offered that would allow a facility to appeal to an administrative law judge if it felt that the Department of Homeland Security's initial IST determination was inaccurate. It seems to me that given the highly technical nature of the safer processes and chemicals involved, that a more suitable appeal might be more scientific in nature. Would you like to talk about that, Mr. Durbin?
Certainly. I think, again, as our members look at this issue, as I said, we're very comfortable with the idea of mandatory consideration. Going further than that, one of the concerns that we have expressed with regard to the provisions in the bill was the lack of a robust appeals process if there were a determination. So by adding one, I think that's helpful, and I would certainly agree that by having folks who are technically proficient in the technologies available here in the chemical engineering and the process safety and health and what have you is going to be a more appropriate way of handling that.
Thank you. I appreciate that. You know, I remember in my first year of college, there were 200 of us in pre-law, and then you had like the 200 over there in theology and philosophy. And then you had the 200 kids who were going to be doctors, right? So it was 200, 200, 200. And then they had inorganic chemistry freshman year for those future doctors. And then sophomore year we had 300 people in pre-law. And then when the additional chemistry and other courses were given, they kept building the number of lawyers. And while I am one of those people who become history and political science majors, our technical capacities are more limited, let's say, than those people who stayed the course. So I think it would be helpful for us to find a way to have scientific determinations be made, even on appeal, that reflect scientists, making these evaluations, so that we don't wind up having some court process where, with all due respect to myself, and any others in this room that might be offended by my comments, making the determinations. So we thank you for that. Tell you what I'm going to do. Let's give each one of you 1 minute to summarize to us what you would like the committee to remember as we are moving forward on the creation of this legislation, just so that we've got your kind of summary statements in our brains. So we'll begin with you, Mr. Portman.
Well, thank you once again for allowing us to be here today. Really, the summary would be that we really would like to see the CFATS program extended. We've got a lot of good work's been done. We want to continue that good work. In regards to the IST issue, we want to just be cognizant of the myriad of programs that we're subject to. Our membership in particular, we have a lot of different chemical processes represented there, and when we make our material, we're making it under registration of different agencies, and if we are asked by DHS to discontinue the use of a chemical compound, it could have ripple effects that could reach out into even consumer safety, where certain active ingredients for drugs won't be available. So we want you to keep that in mind, and also make sure that, as you said, we agree that there needs to be really a technical review, and we feel our people, our engineers, our chemists, are best qualified to determine that per process.
In my summary, I'd like to point out again that the only thing that the bill authorizes the Department of Homeland Security to require implementation of is a facility's own plan. I cannot imagine that some of the examples we've heard today, a plan that would violate the FDA or a plan that would actually make the facility more dangerous, would ever be in a facility's plan. I would like to reemphasize that we do not believe that the ability to mandate this, because of the language that already exists in the bill, is a threat to jobs. I also would like to emphasize that we are concerned about the background check language in the bill, and we do believe it needs to be improved to provide adequate protection against unfair adverse employment decisions. And finally, I want to emphasize that I think that certain parts of the employee participation need to be enhanced.
Thank you, Doctor, very much. Mr. Durbin.
Thank you, Mr. Chairman. At its core, I think ACC members firmly believe that the CFATS program that's in place now is a very solid foundation, a good program, and we want to make sure we can continue the success of that program. And are committed to working constructively with you on finding areas that may need improvement. Again, with regard to the IST provisions in here, our members continue to have concerns about that, but we are willing and eager to continue working with you and the committee on those issues. And as I mentioned in my testimony, we as well continue to have concerns on the civil lawsuit provisions. But again, I think there's much more common ground here than there are differences to help us get to the objective of protecting these facilities.
Thank you very much. And you have the final word, Mr. Ramaley.
Yes. First of all, I appreciate the working relationship between AMWA and the committee staff in developing the legislation. As you know, AMWA supports 3258. A few points. We believe EPA should continue its oversight of the drinking water sector, and our exemption from DHS's CFATS and IST programs must continue. We also believe that wastewater should be included under EPA, as we testified. We think that security information resulting from vulnerability assessments and gathered information must be protected and must be strongly protected against public disclosure. We believe the bill now does that. And maintaining the current criminal penalties is important, but we do look forward to working with EPA to formulate the appropriate standards for the sharing of that information as needed. Thank you.
Thank you, Mr. Ramaley, and we thank each of you for working with the committee thus far. And again, we would like to keep a close working relationship with you and work with the minority as well on these issues. It's been 8 years since al-Qaeda attacked, and obviously I am very sensitive to it because Muhammad Atta and the other 9 were right there in Boston, in my district, preparing for that attack. And in 2000, I'll be honest with you, Abdul Ghani Maskini, who was one of the Millennium bombing plotters for the LAX, he came in from Algeria off of an LNG tank and just jumped off in Everett, Massachusetts, as did other al-Qaeda into the United States, into my district. And that was an LNG facility that was unprotected. Now, they had a different plan, and it involved the L.A. airport, and thank God that they were apprehended before that happened. But I'm very sensitive to that huge LNG facility, to the port of Boston, to what happened, and to my constituents who were on those planes and who actually were working in New York City at the time. So it's something that I've focused on very closely. And why I asked the Speaker to put me on the Homeland Security Committee so I could make sure that we did put in protections that nuclear weapons could not be put on ships that could then be detonated in the harbor of Boston, but any harbor in the United States, that we screened for cargo on planes that we weren't screening. We were screening the shoes that people wore and the computers that they were putting through, but not the cargo that went under their feet of passengers who weren't even on the plane. And chemical security fits into this, as does water security. We know they're out there. We know they want to hit. We know that that they would, in fact, implement their plan if somehow or other they could get through our outer security perimeters, overseas and here. And so we must balance, because the impact, for example, just on Boston alone of that successful attack was we had a 27% reduction in air travel out of Boston in and out for 3 or 4 years. That kills jobs. That kills the economy. That alters people's lives. So they cannot be successful. So we have to find a formula here that works. And by the way, airports across the country might have gone down an average of 10%, just as a derivative of what happened in Boston and in New York City and down here in Washington on September 11th. But all of it was profound in terms of its economic impact. So we have to make sure that they're not allowed to successfully implement a terrorist attack, because that's what terror does. It scares people. They don't fly, they don't move, they don't buy things, and everyone suffers as a result. And we know that chemical facilities are on their list. We just, have enough security information to be well aware that they're very near the very top of the al-Qaeda terrorist target list. And so our responsibilities are great, and we must make sure that, especially in urban areas where these chemical facilities, where these water facilities might be located, if we all could do it again, we would not put them right there in the middle of downtown Boston, right on the harbor, and other cities across the United States. We'd make those beaches or waterfront parks if we could do it all over again. But we didn't do it that way. They're there. They're in densely populated areas. We have to deal with it realistically, try to put together a formula that works, doesn't hurt industry, and comes up with something that does protect the American people. That's our goal. We've very much enjoyed working with all of you so far, and we will look forward to the relationship. With that, this hearing is adjourned. Thank you.
Darius, good to meet you. Meet you too. Give me my